this paper is, the underlying themes of it are really my starting point. My starting point is that if we've learned anything with recent developments in corporate governance, it is that there is not one single problem in corporate law. We have focused really for the last few decades on the alignment of interests between management and directors on the one hand and shareholders on the other, what Enriqueta called the money orientation of things, and that is undoubtedly a critical problem in corporate law. But I think what recent developments have shown us is that an equally important problem in corporate law is how those profits are achieved, and also non-financial risks and how that can cause damage to corporations' reputation. And I think it's this second set of problems in this dichotomy that really underpin this growing interest in corporate culture. And many people see corporate culture as a very vague concept. It comes from sociology, and they wonder how can it be used in law. And so in this paper, what I was really trying to do was to make it concrete in some way, to show how it does matter in law, and to look at the liability implications, because it's often seen as too vague to be helpful. And so I wanted to really look at accountability for flawed corporate culture. And in this second dichotomy, the idea that we are looking at how profits are made and the effect on stakeholders, I've got a different Larry Fink quote here to Enriqueta's, but I think it's also part of this new message about companies are part of the social ether, and therefore we should be interested in how they benefit all their stakeholders, not only shareholders. But that's not what I'm looking at in this paper. I'm looking at, that was what we looked at 2 days ago. Some of you were at the Oxford conference I've just come from, and that was very much the theme of the Oxford conference. But my paper is about how do we ensure accountability when corporate cultures result in harm to stakeholders. So when the corporate culture actually results in widespread systemic wrongdoing in an organisation. So I want to talk about 4 things in this presentation, and we'll see how I do with time, because Elizabeth keeps to strict time. Firstly, I want to look at how widespread is this new development towards corporate culture, and why is it important in the regulatory dialect. Then I want to look at how do we know what it means if it is important. Then I want to look at a few corporate scandals that I think really exemplify flawed corporate culture. And then finally, most of my paper is a comparative analysis of how we could bring that into the legal regimes. And so looking at UK, US, and my own country, Australian corporate law, to see to what extent can companies themselves, entity liability, or directors and managers be legally liable for flawed corporate cultures that ultimately cause harm to a variety of stakeholders. So the first issue then, this issue of how widespread in the regulatory ether, in the regulatory dialect, has corporate culture become? Well, hugely. Everyone is talking about it. Even though it is generally regarded as being a very slippery and elusive concept, I think, Colin Mayer's Future of the Corporation Research Project describes it as an elusive concept. It's elusive, but all the regulators around the world are talking about it. And so I've got a list there from Europe, from the US, from the UK, and it's particularly important in my country, in Australia, as a result of the last 2 dot points here. Australian banks were the envy of the world in the global financial crisis. They were one of the few countries, along with Canada, that did not require a bailout. But they have had a massive fall from grace in the last 2 or 3 years. We've had several high-profile inquiries into banking misconduct, and the banking misconduct has been quite shocking that came out in the Australian Banking Royal Commission, which brought down its final report in February this year. The one above it is a report by the prudential regulator in Australia, the Australian Prudential Regulation Authority. It did a major report into the largest bank in Australia, the Commonwealth Bank of Australia. And both those reports said that Australian financial institutions had major problems with their corporate cultures, which needed to be addressed. When I look down that list and go through the references to corporate culture, one of the things that I think is interesting is that all these regulators and corporate codes seem to take different approaches to why corporate culture, or a healthy corporate culture, is very important. So some say, oh, it's part of risk management, it's part of compliance, it promotes integrity and trust in the marketplace. Others say it's important for implementing business strategy, for making profits. And so there's this sort of split there between a performance-based view of corporate culture. You need a good corporate culture if you want to outperform the market. But on the other hand, there's an accountability theme that runs through some of them, that it's important so that you don't foster misconduct. And I think a really very important example of that latter type of approach comes from the Federal Reserve Bank of New York in 2019. They've released a paper which talks about cultural capital, and what they think of cultural capital as being most valuable for is they think it is a buffer against organisational misconduct. That if you have your cultural capital right, it is less likely that there will be misconduct and fraud in your organisation. So everyone seems to think it's important and that we should be aiming for it, but what does it mean? And part of the problem, I think, with corporate culture over time has been people use the term but they don't define it. Well, they're starting to define it now, and I've got a few definitions up on the screen there. It goes, I think, from the most complex in the British Future of the Corporation project, which talks about corporate culture as a multi-layered scalar social phenomenon concerned with values and related to actions, down to the Australian regulators at the bottom, who have a much simpler version. It's the mindset of firms, according to the Business Conduct Regulator, the Australian Securities and Investments Commission, ASIC. It's the way things are done around here, according to the APRA report, the Prudential Regulator. And I think that last quote, the way things are done around here, brings out a very important aspect of corporate culture, that it is often tied up with organisational hypocrisy, that your ethics codes and the manuals that you give to your employees say it's terribly important to be honest. But the way things are actually done is that corners are cut, and that is not what is expected of you on the ground. I think the other thing that's interesting from these various quotes is the idea that they all view the corporation from a theoretical perspective in a holistic way, that the corporation is something separate from its individual stakeholders, that you can have an organisational culture. And that's different from the underpinning theory that really has driven both law and financial economics since the 1980s. The law and economics theory of the corporation is very much an aggregate theory, that it's just bargains between parties. This is saying, no, there is an overarching corporate reality. Now, that may seem very theoretical, but it becomes extremely important when you look at liability for flawed corporate culture. So, the next issue that we need to look at is how I first got thinking about this, because this is a very hot issue around the world with regulators now, but I became interested in it as a topic as a result of a few corporate scandals that I thought really brought to the surface flawed corporate cultures. And the first one that got me interested in this was the US Wells Fargo banking scandal. Now, it was, many of you will know, fairly low-level employees created many, many false accounts for their clients. Wells Fargo was characterised by an aggressive growth strategy, which was supported by its remuneration practices, and as a result of this, it became extremely successful, third largest bank in the US by assets. Now, the employees were given plenty of ethics training. They were told what they should do, what they should not do. But overlaid on that were these unreasonably high sales targets. And the only way that those employees could hit those sales targets was by fraud. And the fraud was on a stunningly broad scale. There were 3.5 million unauthorised accounts created by employees. 5,300 employees were sacked for engaging in this, but many of them were whistleblowers about the practices that were going on in the firm. Senator Elizabeth Warren said that these employees committed the frauds because they were squeezed to breaking point. And they had both positive and negative incentives for committing this fraud. If they didn't reach the targets, they would get the sack. If they did reach the targets, they would get modest bonuses on top of their quite low base pay. So did Wells Fargo have a corporate culture problem? The company said no. The company said we've got a few bad apples. But the sociologist and anthropologist Susan Silby has said you've got to distinguish between just a few bad apples in an organisation and when you've got rotting barrels. And it really did seem, from the scale of the fraud, that Wells Fargo potentially had rotting barrels. Even though Wells Fargo said that's not who we are, the facts seemed to suggest there were real problems. To me, Wells Fargo was almost like a Japanese haiku of a corporate culture problem in a firm. But of course, once you start looking at this, you see it everywhere. And so then, there were so many scandals around this time, starting BP was earlier, but so many scandals that got me thinking about how this operated in firms where you have this sort of systemic risks of misconduct. And I think these scandals are quite interesting because in many ways they've got similarities to Wells Fargo, but also in many ways they're quite different. So many of them use the bad apples argument. You know, it's just a couple of engineers, software engineers in the VW emissions scandal. But ultimately, many of them had to admit that they did have widespread systemic problems. Non-financial risks really emerged in many of these scandals. Particularly, I think, the Commonwealth Bank of Australia, the second last one. The Commonwealth Bank of Australia was magnificent in terms of its profitability over the last decade. But the Prudential inquiry found that that very success had dulled the senses of the bank to the non-financial risks, where they were basically harming customers and charging them for no service. So making money, but you know, the bank didn't look at how they were making such money. All sorts of different stakeholder harm through these variety of corporate scandals. So sometimes society with the emissions scandal, the BP, PG&E, the California wildfires, citizens died in those. Sometimes customers in the banking scandals, sometimes employees in the sexual harassment scandals. Sometimes it was very easy to identify who the actual wrongdoer was in the organisation. In the banks, you knew who had opened a false account. But in the larger, more opaque organisations, in the BP scandal or the VW scandal, much harder to pinpoint who was at fault. New technology played a big role in some of these. New technology was actually developed to commit fraud in the VW emissions scandal, but in the Commonwealth Bank scandal, part of that scandal involved setting up new deposits, so-called smart deposit system, where they found that $9.8 million had been put in money laundering and terrorism money, which was not good. So, this is the question that I grapple with in the paper. Who should the law target for flawed corporate culture? Usually, if someone commits a crime, you go after that person. But when culture is involved, it becomes more complex. And many people, for example, in the Banking Royal Commission, the Commissioner said, no, you shouldn't have gone after the low-level bank employees because what was really going on was much higher up in the organisation, the incentives that were created there. In the US, over the last 30 years or so, prosecutors have tended to go after corporate criminal liability because it is much easier to establish in the US than in either the UK or Australia. And so they have been bringing actions against companies which are invariably settled, and you get, a non-prosecution agreement, deferred prosecution agreement, etc. But there was a lot of criticism of that after the global financial crisis, where people like Justice Jed Rakoff said, no, people commit crimes, not organisations. You should go after senior management. And that's very much the approach also of Senator Elizabeth Warren, who's asked this question, why isn't Wall Street in jail? Well, the reason why Wall Street is not in jail is because in these corporate culture matters, it's very hard to have criminal liability on the individuals because often the board does not know that this is occurring. It doesn't specifically direct it. And so it's really by omission that they are in any way responsible. But it seemed to me that there was potential here for directors and officers to be liable under civil law as a result of the duty of care and the duty of oversight. And so I examined this in a comparative nature in the paper. So just very quickly, a comparison between US, UK and Australian law. And I'll do this super fast. Oh no, well, one point I will make here is when we're looking at what should directors be focusing on, we've had independent directors ever since Mel Eisenberg's work, but Professor Victor Brudney once said, it's ambiguous what they should be monitoring. And since the 1990s, we've focused on the second of these monitoring activities. We've focused on efficiency and performance, but now I think we're starting to focus on integrity and social responsibility. So to what extent could that aspect of corporate culture come in under directors' duties and officer liability? Well, US corporate law, I was interested, Holger, when you said, it could be in breach of directors' duties, because it is very difficult under US corporate law for oversight liability to attach to directors and officers. Under the Caremark standard, unless those directors have been acting in bad faith, that there is also a breach of duty of loyalty, they will be protected by the business judgment rule and exculpation clauses. And that's a pretty capacious protection. Lots of cases since Caremark have protected directors on that basis. Is that a good system where, directors have so little to fear? Well, Holger's actually written an article where he says not necessarily. That might be too protected. One interesting case, I think, Chief Justice Strine was at the Oxford conference 2 days ago. He gave a very interesting dissenting opinion in this 2017 case. The rest of the court said the directors were protected. The company had polluted a river in North Carolina, but Chief Justice Strine said he thought the Caremark Rubicon had been crossed. And he thought that because he thought the company's whole strategy was to run close to the line of compliance. And he thought it was almost inevitable that these sort of environmental accidents would happen. 2 minutes? 1 minute. UK, you would think that it was much more possible for directors to be liable under UK law. That is because there's been director oversight liability from the earliest time, 1925, and that standard or the benchmark for their conduct went up dramatically in the 1990s with this series of cases. Also, 1999 decision said directors are not just responsible for monitoring performance, they are also responsible for monitoring competence and integrity. So you would think, yeah, there'll be lots of actions in the UK. But procedural restrictions in the UK mean that very few cases are brought, and so directors, not much chance of liability. Joan Loffrey has said there is an accountability firewall in the UK for this kind of oversight liability. And then my final slide is my own country, and I've got a whole raft of reasons there why Australia is so different to the US and the UK. And I think that Australia, we are going to see a lot of legal actions brought for breach of duty of oversight in relation to corporate culture. We have a public enforcement system where it is the regulator that brings actions for breach of directors' duties. And as a result of the Royal Commission, the Royal Commissioner was very critical of ASIC for not bringing enough of these actions. I thought they brought a fair number, but the Royal Commissioner said they should be suing the banks more, they should be suing senior management more, and the new mantra for ASIC is why not litigate? And there are very few places for Australian directors to hide when these oversight actions are brought against them. And so I think that's going to be something to watch in the future, and I think ASIC is gearing up to bring a lot of actions. Thank you.
Thank you very much. That was great.
Thank you, and it's a pleasure to be here. And thank you, Jenny, for really a very interesting paper. I want to sort of approach it indirectly, because it's not that I don't believe that culture is important. I do. 5, 6, 7 years ago, I went out and visited Vanguard out in Valley Forge, Pennsylvania. Talked to them about various things. And you can't walk in to Vanguard's campus without believing that corporate culture exists and that it's critically important. The garden-style campus with uncovered cinder block walls just bespeaks the culture of low cost that Vanguard, and they pay their people less than other people do. It is very clear, the corporate culture is extremely clear. But it seems to me, and the general point I'm going to make in my comments is that corporate culture is a more useful concept from a management perspective than it is from an accountability perspective. Scandals, we know, drive legal change, and not necessarily in a good way. And as Jenny points out, it's scandals that are driving a regulator's increased concern with corporate culture. Bad things happen. Wells Fargo is a good example. Exactly what is bad about Wells Fargo is sort of an interesting question. There was the harm to the Wells Fargo customers from these fictitious accounts being opened was actually quite small. There was a settlement for payments to customers of $142 million, which, given the magnitude of the scandal, is really a very small settlement. The fine imposed by the government was $1 billion, because from a regulatory perspective, they were quite concerned. But the actual harm to customers was not large. We have the Volkswagen emissions scandal, the BP Deepwater Horizon scandal, the numerous sexual harassment scandals. And the question that these scandals always pose for the law is what to do about it, and in particular, what area of the law should take responsibility for it. Is this a matter for corporate law, or is this a matter for criminal law? And the question Jenny's asking us is, what does corporate culture have to do with the answer to that question? And from Jenny's perspective, these scandals raise critical corporate governance questions. For example, how should the law, both criminal and civil, deal with widespread intra-firm wrongdoing due to flawed corporate culture? Should the law target those who actually commit the wrongful acts, or the organization itself, or senior executives and directors of the firm? Implicit in Jenny's approach is that corporate law and criminal law treatments are two approaches to the same set of issues. And moreover, that there should be consistency between them, and that maybe corporate culture is the link. The contrasting view, and the view that I have, is that corporate law and criminal law have different purposes and attack different problems. Criminal law sets boundaries, broadly speaking, within which directors work to increase firm value for the benefit of shareholders. And so corporate law and criminal law need not be continuous or consistent. They're trying to do different things. And I would expect corporate culture to play fundamentally different roles in the different contexts, and that each will have its own internal logic driven by differing goals and differing considerations. And I think we'll see that when we focus on the supposed responsibility gap and the lack of criminal sanctions. So if you think about corporate law from this pretty traditional perspective, the objective is to increase the firm value for the benefit of the shareholders, which we believe that overall is going to be good for society. Boards are the central organ of the corporation. Holding boards accountable is necessary, but, and here is the critical point we've learned in corporate law for a long time, which is, but there's a significant risk that managers will become excessively risk averse. And so the corporate law view of the world is that a little bit of deterrence goes a remarkably long way. That holding directors liable once in a blue moon focuses the attention of directors across the board, and that a greater degree of liability in general is viewed as not in the shareholder interest. A perfect example of that is what we observed in the US with the enactment of 102b7, the post-Smith against Van Gorkum statute that allows for corporations to amend their certificate of incorporation to exculpate directors from good faith breaches of the duty of care. To do that, you had to amend the charter. To amend the charter, you need a recommendation to the board, which you would expect to get if they didn't want to be liable, but you also need approval of the shareholders. And I do not know of a single instance in which shareholders voted against amending the charter to insulate their directors from monetary liability. And this is not a period, this takes place during a period of institutional shareholder concentration. So it's not that these are these are dispersed retail holders. These are institutional investors who made the decision that insulating their directors from liability was in the shareholders' interest. The compliance view, the criminal law view, is a completely different view. And when you go to compliance events, you find a different view. So corporate misconduct, from the compliance perspective, from the criminal perspective, imposes significant harm on society, and controlling it is important both because of that harm and because of concerns of legitimacy. That it's important even if, indeed especially if imposing criminal sanctions will decrease shareholder value, right? That's the whole point. You want to decrease shareholder value, and that provides then the incentive on the board to assure compliance, to avoid that cost. So from the criminal law perspective, the traditional criminal law perspective, there's really no such thing as over-deterrence. The optimal amount of criminal conduct is zero. Fundamentally different approach than the corporate law approach. And so those differing views, I think, pose a question for whether one should treat them as two tools to address the same set of problems. It may be that in Australia, with the predominance of public enforcement of director duties, that distinction between the corporate law side and the criminal law side is going to be blurred. Now, where does corporate culture come into this discussion? We do see it being used widely, for instance, among management consultants, right? When management consultants come into a firm and try to improve management, improve profitability, corporate culture is a critical factor, a critical tool for helping firms become better. But does it provide a useful tool for imposing sanctions? When is bad corporate culture a sufficient threat to society that it becomes an element of criminal law? Now, there are going to be some enterprises that are so destructive and so incorrigible as to justify basically corporate capital punishment. And we've seen instances of that, where the corporation is basically a tool for money laundering and so forth. But that's not the situation that Jenny's focused on. She's talking about places like Wells Fargo, which, as she points out, got through the 2008 financial crisis in very, very good shape. It was held up as one of the success stories. And so the question is, where in these basically productive corporations is corporate culture going to be useful? Is it going to be useful in fiduciary duty lawsuits? I suggest not. That it's not a sufficiently, it's not that it's not a real concept. It is. But it's not at all clear how you can use it in a fiduciary duty context. And it's not at all clear how you can use it in a compliance context. Okay? One of the interesting, for me, the most interesting part of Jenny's paper is the comparative material on developments in different countries, and in particular in Australia, which she tells us incorporated corporate culture into the Criminal Code Act with a goal of casting a substantially broader and more realistic net of responsibility over corporations. And in doing that, jettisoned the narrow PESCO principle that requires that there be an agent of the corporation who satisfies all the requirements of criminal liability. And substituting for that a regime based upon organizational blameworthiness. But what's so interesting about the Australia experience that Jenny outlined is, as Jenny describes it, it's arguably the most sophisticated model of corporate criminal liability in the world, provides directors and managers, in theory at least, with strong incentives to self-monitor and to introduce effective compliance programs to address defective cultures. But then she tells us the potential for entity accountability offered by Part 2.5 has remained largely unfulfilled in Australia. This is because some of the most significant federal statutes relating to organizational wrongdoing explicitly exclude the operation of Part 2.5, thereby undermining the relevance of the corporate culture provisions. And that, for me, raises what I think could be a really interesting discussion in the paper, which is why. What is the problem in Australia with this new, up-to-date, most advanced version of corporate criminal liability for bad culture that led to the rejection of it in so many contexts? And that, I think, goes, if you go into that, I think it goes to the problems that relying on corporate culture poses for traditional criminal liability, the problems that relying on corporate culture poses for traditional concepts of corporate law as primarily focused on providing incentives for the agents to manage the firm for the benefit of the shareholder. So let me stop there and turn it back to Jenny.
Thanks, Ed. That was very helpful and great comments. I just want to make 2 points. Ed points to this dichotomy or division between criminal law and civil law. But as I listened to your comments, Ed, I thought that there was a greater distinction and divergence that you were talking about, which is basically between American law and many other common law jurisdictions. Because, of course, Ed was talking about, well, institutional investors are quite happy having director protection under these charter exculpation provisions under Section 102B7 of the Delaware Act and virtually every other act. Nevada, I think, is even broader in its protection. And he rationalised that as being because the shareholders want directors to make money and they're worried that they'll be too risk averse if they don't get that form of protection. When you look at other jurisdictions, such as the UK and Australia, that is completely prohibited by statute. You cannot exculpate directors for breach of duty of care. And as you were talking, I really felt it went to the heart of what I have always felt was a divergence in how Americans interpret corporate governance and how perhaps certainly UK and Australian and maybe Europeans interpret it. Because the beginnings of corporate governance in the UK were the Cadbury Report, and it was seen as an organisational integrity protection, protecting from wrongdoing. That I think in the 1990s and with financial economics, corporate governance has always been seen as having a performance-based function. And I think that's what we're seeing, this sort of tension between the two. The second point, very interesting, as you say, Australia introduced this sort of organisational blameworthiness provision based on corporate culture. It said the corporation can, not the directors and officers, but the corporation itself could be criminally liable if it had a culture which either encouraged or tolerated breaches of the law, but then that was, gutted for political reasons. One very interesting thing at the moment is the Australian Law Reform Commission has a major inquiry, and we don't know which way it's going to go, whether it will get rid of that act altogether or whether it will say, no, it's now going to go in and you can't subvert it anymore. So that's a space to watch. Thank you.
Sufficiently Americanized to share many of Ed's views, even though in the law the distinction may not be drawn, though, in Australia or the UK. I think analytically it's still very helpful to think about whether we're talking about culture in as much as it benefits shareholders or it hurts shareholders. And I think we know, for example, from Uber, that breaking the law can be very profitable. And we need to distinguish those two things. I think there's a good case from a public policy perspective why one might want to insist as a policymaker or an academic writing about it, that there be liability for a corporate culture that facilitates these acts, because, the general problem is something happens, we can sort of think that there's responsibility in, I think you call it omission, in a diffuse way, but we all know that from a prosecution point of view, one can't pin it on the right people. One can go after the individuals on the ground who did it, if one can pin it on them, but it feels wrong because one understands that there's a bigger system behind it, and it's probably not the most effective way of doing it because the pressures on the ground might be so high that people do it anyway. So I think it's worth thinking about whether, be it through civil liability or through criminal law in the form of an offense, which would be of the nature of not fixing a bad culture. You have to be more specific, but you get what I'm saying. We go after this. I don't think Ed would say anything different. It's true that the optimal amount of intentional crimes is 0, but the optimal amount of crimes not prevented is not 0, because you can't prevent any crime. The top people can't prevent every crime, but some of those organizations, that's what you're talking about. I think the bad actions are so widespread that one thinks that with if somebody at the top had wanted to, they would have noticed and they would have done something about it, and we want to set the right incentives that they actually do that. And the only question is, can one do that without destroying too much good stuff at the same time, right? That's the real question.
So I think culture and the business model can't be distinguished, or they need to be thought of together. So, for example, the case of banks, which has influenced so much of the thinking in this area, the failure of a systemically important bank matters quite extremely, whereas the failure of a non-financial firm doesn't. So the risk-taking behavior by each ought to be different. And so the idea that there's a culture that would unify them, I think, is going to be making sort of a category mistake. In the U.S., the best defense of the Volcker rule is a culture rule. His defense was that if you take proprietary trading outside of the bank, then the traders who otherwise would ascend to the top of the bank will be off at the hedge funds, and you'll have a bank run by commercial bankers, which will, by the very nature of the business model that they are engaged in, change the way the bank sees risk. So it's not just the liability standards, it seems to me. It's the way, it's the expectations we have for the riskiness of the venture and the way that constraints may come to play in the role of the permitted level of activities where you're dealing with a financial firm that generates the culture that is then going to be the focus of analysis.
Can I just ask Jeff one question? Jeff, if I remember correctly, your paper with John Armour, talks about those different risks, and I think you say that the business judgment rule shouldn't therefore necessarily have as much, shouldn't be as capacious in the bank context. So this is part of that. Yep. Right. Yeah. Great.
Now, there's an enormous literature on culture. And one quote that I liked a lot and still like a lot is the following, which is organizational culture is a complex phenomenon, and we should not rush to measure things until we understand better what we are measuring. I think what makes culture really valuable within corporations is precisely that it's hard to define, it's hard to measure, because it's what binds a corporation and leads people to behave in some specific ways when there are no written rules. Now, and what scares the daylights out of the discussion about targeting culture with law on putting regulators focused on risk management is that we attempt to write things down and have precise rules of what culture ought to be, with the result being of destroying the usefulness of culture for organizations. So I think we should be quite careful. I have close and personal experience with Australia on culture, and I don't think that that's a very good direction to go into, in the sense that it is very dangerous in terms of the health of institutions.
If I can just have one quick response to that. That was what I do agree with you, that if regulators go in and just say, we don't like your culture, and that was why in this paper I really restricted to where the culture leads to widespread wrongdoing. So it's not the culture per se that I'm saying should be regulated, it's wrongdoing that arises as a result of culture.
Thank you. Well, let's go to the back. Yes.
Yeah, so this actually follows up on Renee and your comment to that. I mean, because there is this tricky question in culture of what we're trying to get. And you're saying, well, I'm not really worried about culture in all circumstances, I'm only worried about future outcomes. But the question is, how do you know at post that you had the environment that was so problematic, it was clear that it was going to lead to that outcome, which just goes back to Holder and Ed's discomfort with liability. And I think it goes back to Jeff's point about structure. I mean, one of the things we're looking at in the bank space is very hard through liability to figure out, okay, did you have a sufficiently bad culture that you can hold them reliable? So then there's a question of can we do this regulation? And even there, that's proved incredibly difficult through supervision, which is very hands-on. But the bright space, I think, in the banking area has been efforts to think, well, what can we do structurally in terms of activity restrictions or in terms of growth restrictions that might have indirect effects on culture? So Jeff mentioned the local rule, and I think a lot of people think, regardless of whether they liked it initially, there has been significant spillover effects on culture because you're not only taking away people who are most risk-seeking and they're now going to hedge funds, but people are no longer looking at their colleagues who's making more money than them, and it's not somebody who's out of process. But it has filter effects throughout the culture. One of the efforts to go back and try to figure out during the quiet period, why was it that the U.S. had such a stable financial system and got staples there? One of the stories that has been provided is that by forcing commercial banks to be separate from investment banks, we were forcing a culture of banking that was boring. There's some more things right now with Wells Fargo. It's not just that they got fined, they also had a growth restriction. And I think people don't see the growth restriction as being about, okay, well, how do we make sure that they don't have a bad culture? It was their efforts to grow that led to a lot of problems. So the Fed has said, okay, we're not going to let you grow until you actually show that you kind of fix something more meaningfully internally. But I'm just wondering if you want to add structural considerations in there as a tool, even if you do care about culture, as potentially a more promising way of achieving the desired outcome.
You say that the regulator might come and say, I don't like your system of culture. Another regulator can come and say, I don't like your system of incentive. But wouldn't there be a big overlap between the situations in which those statements would be made and when you think about situations in which we have a great system of incentives to do the right thing, but somehow if you do the wrong thing to the culture or vice versa?
I can certainly think of instances where you have a great system of incentives, but people still do the wrong thing. Whether that would be a bad apples situation, I think in these organisations there were why would they? I would have to think that through, but I think a variety of reasons why you might. You know, if you thought you were only going to be at an organisation for a short time, you weren't in the long term, and you thought you could, you know, commit fraud, you know. But I think in these organisations, I certainly think the Australian regulators see culture and incentives almost as identical. And I think in the Banking Royal Commission, the cultural problems they perceived came out of the incentives from financial remuneration. So that's not answering your question, but I think they're almost intertwined. Yeah.
So a question I had which sort of relates to some of the earlier points is about how you operationalize this, especially from a corporate liability perspective. And in the early part of the paper, you sort of make the point that provisions relating to putting a more stakeholder approach into the corporate law and liability opens up the potential for culture coming into liability for directors. So I think you mentioned Section 172 of the UK Act of that. But the question I have is, when you're dealing with introducing a more stakeholder approach into the law, you could actually be going against another culture, which is a culture focused on shareholder orientation. So it's just very hard, I think, to operationalize the concept of culture. And what I was, maybe the question I had, and I find this all very fascinating and interesting, but is, you know, how do you actually, do you think that culture can be operationalized as a mechanism for actually holding directors liable at the end of the day? And how do you see the connection between stakeholder approach and culture? Because I think whereas culture is malleable and it can take a shareholder approach or a stakeholder approach or another approach, when you're trying to pin liability, you have to pin a standard, right? And I think that that's where stakeholder approach has found its way into liability and can be operationalized. My feeling is that culture cannot be operationalized as a legal tool to pin liability. And I was just wondering if you think that that's a possibility.
I've never been a fan of stakeholder approach to directors' duties because I think it's too diffuse. I think that it gives too much discretion. And I think a lot of people think that the Australian Banking Royal Commission is a sort of stakeholder document. I don't think it is. I think that everything that is complained about in that report was an actual breach of the law. And so it's looking at, there were breaches of the law that had a very deleterious effect on stakeholders. It's not saying the directors had to, you know, be looking at balancing everyone's interests. It says very clearly the directors had one role, which was to act for the benefit of the organisation. But by harming certain stakeholders, they destroyed the reputation of their organisation. So it comes in at a much more peripheral level. It's very much focused on these directors had one duty, and that was to act for the benefit of their organisations, and they failed in that because they ruined their reputations.
Jenny, I guess I have an implementation question too, although I think it reflects some of Ed's concerns and others that have been expressed here. So on the one hand, you could have amounts of damages that, you know, are so great they're in essence draconian, which really makes this like a criminal process, but with a much lower burden of proof. I'd really question whether that's what you're trying to accomplish, but if you had lower levels of damages, I wonder whether, in fact, the civil liability, in essence, whether these are derivative suits that that lawyers would think were worth bringing.
Great question. I've always thought that in the US context, one of the reasons why the courts do give directors so much protection is, I think Gagliardi's case says, these are stratospheric damages that could be brought against the directors. Most of them are independent, non-executive directors. We cannot expose them to that. Traditionally in Australia, that hasn't been a problem. It's been more like your article, where there's been a capped amount because the regulator brings the actions, and they haven't been particularly huge penalties. And so, yeah, you get hauled over the coal, it's publicly embarrassing, you're in the newspaper, but you have to pay $30,000 in damages or something at the end of the day. That may all be about to change in Australia, because a new act has just come in last month which radically raises the penalties that the regulator can seek. But also, Australia in the last couple of decades, for the first time, has got class actions, and they are now starting to flow through and be used much more frequently. And I do wonder if Australia gets to the stratospheric damages position, whether the courts will pull back and behave in the same way as the US courts.
I have a question about collusion. I think a collusion is a very good example where there will be a conflict between shareholder value and integrity. I don't want to use culture because it's very elusive. Let's just focus on integrity. So about 10 years ago, many of the Korean construction companies colluded to get a procurement from the government, but they were caught. They received a heavy penalty from the Fair Trade Commission. So the criminal case went along. But now the shareholders want to take the directors accountable. They want to file a derivative lawsuit, which is a civil case. So the question is, are they the directors of those construction firms who broke the law, who's not, lost integrity? Can they be accountable for collusion? Because if you collude, you make a lot of profit. So, but that has been gone away because of the penalty. So there's nothing harmed in respect of the firm. Can the shareholders, can they still file a lawsuit against them? I'm asking this as a non-lawyer, how that would work in a country like Australia, and how differently in the United States.
Well, I mean, that's a classic Caremark situation where the company is, subject to a big fine, and then the shareholders go after the directors and say, well, you weren't performing your role properly because you allowed this to happen. In the US, it would be difficult to prove under Caremark unless the directors were actually complicit, if there was collusion and they were complicit. In Australia, I think much easier to find the directors liable under, I didn't talk about it, but there's a particular form of liability in Australia that's developed in the last maybe 5 years called stepping stone liability, which is if the company breaches the law, or a recent 2016 case says, or if the company has acted in such a way not to breach the law but to ruin its reputation, then the directors can have kind of ancillary liability for allowing that to happen. So different approaches in different jurisdictions.
So I just wanted to say a couple of brief things about corporate culture from an internal or a company point of view. So if you're on the board of directors and you want your company to maximize profit subject to adhering to all the laws, but you know that you can't monitor everybody, and you know your senior managers can't monitor everybody. So from the point of view of a board, what would a good corporate culture be? A good corporate culture will be that employees who can't be monitored have internalized the way to behave so that they make money the way the board would like them to make money. And that would be a good corporate culture. And from that point of view, I'm not sure that you really need any law to help you out in having a good culture, because the profit motive gives you a motive to have a good corporate culture. And if you have bad managers who don't know how to implement a good culture, then you fire them and get managers who can. So I think a lot of this debate about corporate culture essentially has nothing to do with corporate culture. What it has to do with is what additional duties a company should have besides making money. And I think it would be clarifying to drop corporate culture from the legal aspect of it, because it's really a private matter, and then talk more clearly about what it is we want companies to do in addition to making money. Or perhaps, as Jeff said, whether or not companies, whether we want to evaluate their business model. Because if you have a business model that's socially undesirable, you can have a great corporate culture in the sense that everybody not being watched is implementing that bad business model to the max. So I think what we should be talking about is duties of companies in addition to making money, or possibly what are good or bad models of corporate behavior. But I think that the cultural discussion essentially has nothing to do with what is important to people in this debate.
Thinking about liability rules, one standard argument in this scenario always is if you open up the standards for directors towards a stakeholder approach, or in your context, the elusive concept of corporate culture, it makes it easier for directors to escape liability, because they can always say, well, you know what, that might have been bad to shareholders, but it's good for employees or the general public. Now, you're telling us for the Australian example that it actually led to more cases being brought by the public authorities. That can be probably attributed to a sort of political economy of bureaucracy story. So if you give the power to the regulator, they will simply snatch it. So my question is, any indication if this amount of litigation that obviously has increased does any good to the firm? And so is there any indication that firm value increased, or did it decrease, or anything to that respect?
Bias, it's like the French Revolution, too soon to tell. This has all only just happened, this final report of the Banking Royal Commission, but it has made a major change structurally to ASIC. ASIC now has a new enforcement wing. It's hired all these barristers to sue, and it is not clear whether it will, be a good thing or a bad thing. They were hauled over the coals in the Royal Commission for doing too many enforceable undertakings, which were like negotiated settlements. And the Commissioner thought that the businesses were basically writing their own settlements. But negotiated settlements are great because you don't know what's going to happen if you go to court. So I think it's all quite unstable at the moment, whether ASIC will, I think initially they'll have to go to court much more often, but if they lose, then it's back to the drawing room, or board. Yeah.
I like culture talk, but I would like to know your specific image of corporate culture. What type of corporate culture will induce the corporate scandal, and another type of culture will prevent the corporate scandal. I'm from the country we proud of long time, good corporate culture, and the the people of the Japanese companies always pursue the customer value first, and not only pursue the money value. But recently, unfortunately, I need to report you so many corporate scandals who cheated the customer fraudulently. And so it's not only one or two. Many companies have been done such a bad practice. So far, I cannot understand the specific image or example which type of culture can be more, less corporate scandal. So that's my question.
Well, I think this also goes back to Alan's question, which I didn't really respond to you, Alan, but I'm happy to chat later, that your ideal model is where the employees have internalised an ethical and proper way of doing business in order to make lots of money. That's great, except in a lot of examples, certainly the Australian financial institutions, that wasn't happening. They were making a lot of money, but they were doing it by improper means of harming customers, etc. And to me, when I think about the results of the Banking Royal Commission in Australia, The problem is, I don't know that the boards knew what was going on, but I think they're trying to force information up to the board more. And once a board does know that improper conduct is occurring, then I think they really do have to do something. And what they would clearly like them to do in Australia is to go straight to the regulator and self-report. And I think what may change things in Australia is much stronger protection for whistleblowers, because they know what's going on below these subterranean levels in the organisation. The board often doesn't. But if you can force information up, whistleblowing's not ideal. It's a horrible last, you don't want it. But what you do want is employees to feel that they can talk about if they're uncomfortable with something. And clearly people at Wells Fargo couldn't, because they tried to and they got the sack. So I think that is a good culture, where it's transparent and where people are encouraged to, walk the walk.
Great. Thank you so much, Jennifer. Thank you too.